November is a great time to be thankful for the assets you've built, and the smart business owner knows that the intellectual property, or IP, protecting their unique creations is one of the most valuable assets of all. But once you've invented that brilliant gadget or coined that killer brand name, who do you hire to protect it? The choices can feel like a maze full of shadowy corners and false promises. Should you DIY and brave the journey alone? Rely on a map from a cheap online service? Or hire an experienced intellectual property lawyer as your seasoned guide? The cost difference seems huge up front, but I've spent over 25 years as a lawyer watching that initial savings turn into a financial catastrophe down the road. I'm Julie King, your rock and horror-loving patent attorney. Welcome back to the recently renamed podcast, Spellbinding IP, Patent, Trademark, and Business Strategy, formerly Know Your Rights, Your IP and Business Law Playbook. While that title entertained me because it's a Clash song title, it wasn't so good for reaching people looking for answers to the IP questions, so an SEO-friendly change was needed. But enough about that. Back to the real content. Today, I'm leading you through that labyrinth of confusing options to show you 4 specific high-stakes mistakes that only a licensed intellectual property attorney can prevent, proving why the cheap path often leads to a worthless asset and spending more in the long run. I'll also cover how to choose the right lawyer or law firm to help you. Before we expose the fatal flaws, let's recap the 3 primary paths small business owners consider. Number 1 is the DIY approach, filing applications yourself based on information from the USPTO, which is the United States Patent and Trademark Office website. Number 2 is the automated horror show of online services. Services like LegalZoom or Trademark Engine that prepare and submit forms for a low, flat fee. Often they are not law firms and cannot provide legal strategy, though sometimes they do come with a lawyer-assisted service. The third is the true counsel, hiring an attorney. Securing a licensed intellectual property or patent attorney like a solo or small firm who provides strategic advice and technical drafting. The danger lies squarely in paths 1 and 2. They allow you to complete the paperwork, but they often leave the actual protection fatally compromised. So now we'll look at the 4 fatal flaws that an attorney can help you prevent. Number 1 is the claims killer, the fatal flaws of DIY patent language. A patent is a highly technical legal document. The claims, the part that defines your legal rights, must be drafted with precision. That's because in a patent, the claims define the legal boundaries of your invention. If the claims are bad, the patent can be worthless. Here are the flaws in that. Calamitous claim language. Claims must be written in a technical way that arrives at balanced, Goldilocks approving, not too broad and not too narrow definition of the invention. Non-attorneys, DIY or online services, often write claims that are merely descriptive of the product's function or that simply describe the preferred embodiment, which is the best way the inventor built it. This is a technical, legal, and difficult, if not impossible to fix mistake. Dismal descriptions occur too. The law requires the patent claims to be supported by a description that satisfies 35 United States Code Section 112. That means everything in the claims must be supported by the written description of the invention in the patent application by being mentioned specifically in consistent terminology and in context with the other parts of the invention. DIY and online services often produce a description that's simply inadequate to support the claims. Also, everything claimed in a non-provisional application must be supported by something in the provisional application in order to use the provisional application's filing date, which is the main point of having a provisional application. It's easy to overlook content that should be included in the provisional application. Sometimes the online services may be misleading. Now, not all online services are swindles. Some are, but most of the long-established ones offer some legitimate help. Whether that help is what you need or worth what you pay for is something more subjective. Here are my personal takes on some of the common online services. I am not saying they are scams. I'm just saying be careful and be informed about what you're truly buying and what you're not buying. These services have sometimes worked well for some people, but a good online search for the reviews is a smart move, and that goes for any lawyer or legal service you're thinking of using. Let's look at InventHelp. InventHelp advertises on news shows and daytime TV and charges thousands of dollars to give you marketing assistance that my clients who used them first said was nearly useless. They don't even offer patent application services. You just pay them to refer you to a more affordable patent attorney. I'm using a lot of air quotes today, but that's because it's necessary. Why would you pay for someone to refer you to a patent attorney when you could find one for yourself for free? Also, and here's the really important thing to take away about InventHelp and other services like them, disclosing your invention to this service can result in public disclosure that starts that 12-month filing window clock that many inventors don't even know exists. These services tend to keep that issue pretty quiet. Now, the New York Times reported in 2016 that less than 0.5% of InventHelp's clients got the results you'd expect. Quote, of the roughly 6,000 clients who have signed agreements with InventHelp in the past 2 years, only 153 have successfully obtained license agreements for their products, company officials said, and only 27 have wound up making enough in profits to recoup what they paid for InventHelp's services. The link to this news article is in the written version of this post on my website at kingpatentlaw.com. Let's look at LegalZoom now. LegalZoom's patent practitioner-assisted patent application service is, for their advertised prices, essentially document preparation with brief advice. Note that I didn't say legal advice, and that's because sometimes that patent practitioner will be a patent agent who can't give you legal advice. Their application services are extremely limited in terms of number of pages, drawings, claims, and revisions. If you pay for a utility patent search, you get a report, and then they only assess a whopping 3 prior art references chosen by you. They don't even guide you as to which ones you should focus on. In their utility patent services agreements, they fully admit that, quote, only a cursory inquiry is made into the details and scope of the invention. Thus, important aspects may be overlooked by you and or the practitioner, end quote. They also admit that, quote, there are various limitations on page length, number of drawings, number of claims, and number of drafts in the limited services. This could be disadvantageous to you, end quote. You can contract with the attorney or agent for additional service, but that's likely going to bump you up into a fee level closer to what you would have paid for a patent attorney or agent in the first place. So you may as well just hire one you choose yourself at the start and get more personalized service at the level of detail you need. You can see for yourself exactly what is and isn't included at the links that I have in the written version of this post on kingpatentlaw.com. They are links to actual LegalZoom terms of service for their patent services. Now we're going to talk about Fiverr. I feel like I shouldn't have to explain why hiring a lawyer on Fiverr is a terrible idea. But here we go. First, and most importantly, there is no guarantee that the person you hire is, number 1, who they say they are, or number 2, a registered patent attorney or patent agent. Now, if you use their pro services option where there is at least some vetting of the providers, you'll notice that there are none who offer patent application services. Think about that. The government has some guidance on using online services as well. The federal government urges caution. In the written version of this post, there are links to what the FTC and the USPTO have to say about online services and protecting yourself against the worst of them, as well as what to do if you are swindled. And keep in mind, the scams are getting more sophisticated all the time. It is entirely too easy to fall for them. You don't have to be an internet newbie to fall for some of these scams. When in doubt, do a little research, look at reviews. Because here's the disaster that can happen if you use an online service that doesn't measure up. Pointless provisionals. If the description and drawings in your provisional patent application aren't thorough enough, you won't be able to get the advantage of claiming priority to its filing date. Everything in a non-provisional application must be supported in the provisional application in order to use its filing date. It's often difficult to make that happen without attorney or agent guidance. Careless claims. If your claims are too narrow, a competitor can easily make a minor change to your design and legally design around your patent. I've even talked about how to do that in a previous post. If your claims are too broad, the USPTO may reject them as being precluded by existing prior art, wasting years of your time and thousands of dollars in fees in trying to get that patent application approved. It's exceedingly difficult and sometimes impossible to change claims the way you need to once they've been submitted. Now, certain changes are allowed, but they may not be enough to rescue the application. Here's the attorney solution. A patent attorney who, like a patent agent, has a technical background but also has a legal background a patent agent doesn't have, and who can give you legal advice, whereas patent agent is not allowed to, is trained to draft claims that are broad enough to cover potential infringement, yet specific enough to be novel. This is high-stakes legal drafting, and it deserves to have a skilled practitioner do it. Now we'll move to fatal flaw number 2, the trademark zombie, and why a bad search can doom your brand before it's born. A trademark must be unique, and making sure it is before filing an application requires a thorough clearance search. The most frequent mistake here is an incomplete or non-strategic search. A proper trademark search considers not just identical registered marks, but also similar marks that are confusingly similar in sound, appearance, meaning, or that are used with related goods or services. Many DIY filers also incorrectly identify the legal owner of the mark, say individual versus the business, or they use an overly narrow description of their goods and services, which can be a non-fixable mistake that requires starting over and wasting all your initial filing fees. These kinds of mistakes result in trademark zombie applications, which are filings that look alive but have no real legal substance. Here's the flaw. Many DIY applicants don't do any search or just search the USPTO database. The problem with only searching the USPTO database is that it only contains applications and registrations. The thing is, your brand can also be blocked by common law rights, which are unregistered marks already in use. If a nearby competitor has been using a confusingly similar name longer than you have, they may be able to stop you from using even your federally registered mark in their region or sometimes nationwide. Your mark could be canceled. Cheap online services also often check only the federal USPTO database for exact matches. Some do more through an AI-only search, but then they give you the results without a thorough analysis and explanation of the results. Let's look at some of the popular online services like we did for patents. First, let's look at LegalZoom. Now, just because plenty of people get their trademarks registered through LegalZoom doesn't mean the registration is good. It doesn't necessarily mean it's bad either, and that's not what I'm saying. It just doesn't necessarily mean it's a quality registration. I just checked their website, and they don't appear to have a DIY service anymore, which is an improvement, and I'm glad to see that. They only have an attorney-assisted service. That's much better. If you have to use an online service, LegalZoom is probably your best bet. However, let me tell you a story about a client of mine who began using their attorney-assisted service. My client owns a restaurant and sells some sauces to go, as well as shirts and hats with the restaurant logo on the front. He sells the hats and shirts online as well. He wanted to start selling the sauces and some of the other products in grocery stores. He hired LegalZoom's attorney-assisted trademark service. The attorney ran an AI-assisted search. It's not a bad search, but the attorney didn't seem to have also done any manual searching, which is still necessary since AI is not perfect. We've all heard the horror stories about AI making things up, and AI trademark searches miss things. I know this because I use them as part of my own searches. They're just not perfect yet. The attorney gave a reasonable assessment of the results. Here's where we get to the problem. The attorney advised my client to file in Class 25 for the shirts and hats and Class 30 for salsas. He got Class 30 correct. Class 25 was not proper because the client's use of the logo on the shirts and hats was merely ornamental, only on the front, not on the tag or other brand identifying place, like maybe on a pocket. That class would have been rejected. Here's the worst part. The lawyer didn't suggest my client file in Class 43 for restaurant services, despite restaurant services being the core of my client's business. The client had a gut feeling and felt uncertain about the advice, not knowing just how bad it was, and came to me for advice and actually doing the application. Now let's look at Trademark Engine. Just don't. Just don't. Especially their basic package. Learn a little bit on the USPTO website and do it yourself instead if you can't afford a lawyer. Trademark Engine has an F rating with a Better Business Bureau. Customers report the final cost being much higher than expected due to unexpected fees. You can see the consistent complaints at the Better Business Bureau's website, and you can find the link for that on the written version of this post on my website, kingpatentlaw.com. Here are some of the disasters that can happen. You file your federal trademark application, spend money on branding, spend time building your brand, and then receive a cease and desist letter from a company that has been using a confusingly similar name in your region for 5 years. They can block your federal rights locally, exposing you to an infringement lawsuit you'll lose. Worse, you receive a cease and desist letter from a national business that has a confusingly similar mark for similar goods or services. Then you have to rebrand entirely and often quickly rather than at your own pace. Then there's this kind of application, which is utterly doomed from the start because the lawyer filing it, who is a business lawyer and not a trademark lawyer, had no idea how to fill out the application properly. Honestly, I thought it was a DIY application because it was so flawed. You can find a link to this application on the written version of this post on my website, or you can search for serial number 9097001057 in the USPTO trademark database. The applicant, where you're supposed to put the mark, put, quote, "The word lake," in all caps, featured horizontally with the word junkie located and centered below the word lake. The letters of each word are designed in block style, thick in size, and have angled straight edges such that no edge of any letter is completely horizontal or vertical. Each letter is filled with cutout sections to imitate the movement of water in a wave-like pattern, sporadically placed throughout each letter. The wave ripples run horizontally. Now, there's nothing wrong with that description of the mark, but you don't put that in the field saying what the mark is. What the lawyer should have done is selected an image mark application instead of a text mark application, submitted an image of the mark, and put that description in the description of image field. The specimens of use also only showed ornamental use and would have been refused, and they didn't even all match the description. This is why I say if you're going to use a lawyer, use one who does trademarks as a core part of their practice. The attorney's solution really is an experienced licensed trademark attorney who performs a comprehensive legal search and analysis, searching federal and some state registrations that are available online, domain names, social media, business directories, and general use on the internet, looking for not just the obvious potential problems, but also the ones that are nuanced, mitigating the risk of being ambushed by a prior common law user. The strategic search is the necessary due diligence that protects your investment in your brand. An experienced trademark attorney will also know the correct classes of goods or services to file in, the proper specimens of use to file to prove your use of the mark in commerce, and how to navigate a host of other small but crucial nuanced issues. Note that I said use an experienced trademark attorney to do this. The example I gave above shows that your business attorney who dabbles in trademark applications likely doesn't have the experience with the nuances with trademark law any more than your trademark lawyer has experience with the nuances of corporate mergers. It's like asking a heart surgeon to do brain surgery. They may do okay, but do you want to risk it? Recall that example I gave in the disaster part of this section and ask yourself, is that worth the risk of not using a trademark attorney? Many trademark attorneys, including me, offer a DIY assisted service that includes actual legal advice and making sure your application doesn't contain any flaws that would obviously be a problem for registration. Sometimes that will include a quick search to check for identical hits in the USPTO database and in general online use. You can also try to find an intellectual property law school clinic near you that may be able to help if you can't afford a lawyer. Here's fatal flaw number 3, the copyright trap, which is filing too late to claim your full damages. All right, content creators, you know your digital painting, script, or video is protected the moment you create it. But if someone infringes it, do you want to recover $50 in lost profit, or do you want the full weight of the law on your side? Copyright is automatic upon creation, but that initial protection is weak in a fight. You must register to secure your full legal remedies. Here's the flaw. Creators, especially online streamers and podcasters, often wait until they are being infringed to file their copyright registration. And here's the disaster with that. To be eligible to recover statutory damages up to $150,000 per willful infringement and attorney's fees in a lawsuit, you must register your work before the infringement occurs or within 3 months of its first publication. If you miss this deadline, you're usually stuck proving your actual damages, which is just lost profit, and which is often very difficult to prove and costly. The solutions are twofold. You can consult a copyright attorney before you create something, or right after you do. We advise you on the legal definition of publication and ensure your filings are timely and correct. We help you strategically use cost-saving options like group registration for a series of works to preserve your rights to the most potent remedies the law allows. And here's the nice part about copyright registration. You don't necessarily need an attorney the way you do with patents and trademarks. The copyright.gov site has wonderful training and educational materials designed to help creators be able to handle their own copyright registrations. Why? Because creators often need to register many, many works, maybe hundreds or thousands. Think of how many a professional photographer would need to register. Paying an attorney to handle all of that just isn't feasible for most creators. If you really feel nervous about DIY, and it's not something you'll do often enough to become comfortable with it, by all means, use an attorney. But if you're going to need to register works often, though, perhaps hiring an attorney to show you how would be worthwhile. Without timely registration, you might be stuck proving every penny of your actual damages, which can be very difficult and make the cost of litigation prohibitive. Don't fall into the trap. Ensure your copyright registration paperwork is filed on time to secure the highest level of protection for your creative works. Now we'll look at number 4 out of 4 fatal flaws. Who owns the asset? The intellectual property time bomb in the business. This is a business law issue that can have devastating intellectual property consequences and can even tank the business. When you start a business with a co-founder, friend, or partner, who legally owns the brand, the software, or the product idea? If you don't have a legally binding agreement about it, the default answer usually is everyone who created it, leading to a potentially expensive legal time bomb. But that's just the beginning of the horror. Here's the flaw. When forming a business with a partner, such as an LLC or partnership, founders often use a basic, generic operating agreement, sometimes provided by online formation services, or sometimes one they just find online somewhere that fails to explicitly assign IP ownership to the business entity or fails to license it to the business, fails to detail what happens if an owner leaves or dies, or fails to have any details about IP ownership at all. This is the disaster that can occur. If a partner or member leaves, is fired, or passes away without the IP rights being addressed properly in the operating agreement in any necessary assignments or licenses, they or their heirs may legally claim co-ownership of the business name, trademark, the logo, the patent rights for your main product, copyright of the content on your website, or the proprietary recipe behind your wildly successful cupcakes. This is the legal time bomb that can effectively kill your company in a hostile ownership dispute. Here's the attorney's solution. A business lawyer drafts a custom operating or partnership agreement that includes specific mandatory language regarding all intellectual property related to and important to the business. This keeps those assets secure regardless of personnel changes. Moving on to part 3 of this episode, how do you find the right intellectual property professional? Hiring a licensed patent or IP attorney is the strategic professional practice that minimizes risk and maximizes the value of your assets. But the choice is still complex. Solo small firm versus big law or large firm. Let's look at some of the differences. So the typical hourly rate for a solo or small firm like King Patent Law is generally $250 to $450 an hour, and they often offer flat fees like I do. Whereas at a large firm or big law, it's going to be $500 to $1,000 plus per hour. Solo and small firms tend to attract and serve creative entrepreneurs, startups, and small to mid-sized businesses, whereas large firms and big law tend to serve large corporations and institutional clients. The benefits of a solo and small firm include efficiency, direct communication, and a holistic business IP strategy. Whereas the benefits of a large firm or big law can be the depth of resources, such as attorneys that cover many different areas, litigation, and complex global portfolios. Finally, we get to the vibe. The solo or small firm will be personalized and responsive and understand budget constraints. The big law or large firm is going to be more formal, more structured, and have higher overhead. Let's also look at patent attorney versus patent agent because it's vital to know the distinction. A patent agent has a technical degree and has passed the patent bar exam. They're authorized to prepare and prosecute patent applications before the USPTO. A patent attorney has also passed the patent bar exam and is authorized to prepare and prosecute patent applications before the USPTO, but additionally has completed law school and passed at least one state bar exam. The real difference is that an attorney is a fully licensed lawyer and can provide legal advice on strategy, infringement, licensing, contracts, and litigation risk. By law, an agent cannot advise you on related legal matters, such as drafting your non-disclosure agreement or licensing agreement, and those are often critical to protecting your invention. For the creative entrepreneur needing a full suite of business protection, patent, trademark, copyrights, and business contracts, a patent attorney who also can handle trademarks and who also knows how to handle business law or has a business law partner is the essential way to go. Here's the takeaway. A solo practitioner or small IP firm is often the sweet spot for small business owners. You get the benefit of a seasoned licensed attorney like me with my over 25 years of experience, with the flexibility and cost efficiency that big law simply can't offer. And unlike online services, you get a partner who understands your short and long-term business goals, not just a document filer. Once you've narrowed down the size of the firm you want to work with, finding the specific firm or attorney does require some additional work. Getting a referral from someone you trust is a great way to find a good attorney. Doing an internet search and looking at online reviews is smart too. Just make sure to look at the actual reviews and any responses, not just the star rating, because sometimes the attorneys get spammed by opposing counsel, opposing parties, or just randos who never even used our services. If you find some that look like good options, Visit their website and see what the vibe is. Do you want a firm that's been around for 150 years? Do you want an all-woman firm? Do you want a traditional suit and tie at all times lawyer? A non-stuffy attorney? Maybe you want an attorney who loves rock and roll, punk rock, and horror movies. There are lawyers and firms out there to match with any of your preferences. So, the bottom line is choose your guide wisely. You can't afford to treat your valuable assets like a low-budget horror flick. Choosing your IP counsel isn't a place to pinch pennies. The money you save on cheap service is often dwarfed by the cost of fixing an application error, or worse, realizing your final patent or trademark is too weak to actually defend your business, or finding out that your business is set up in such a way that any change in personnel creates utter disaster regarding intellectual property. Choose a legal partner who brings years of the right experience and strategic foresight to the table, and who also knows where their expertise is and isn't. Don't let your business's most valuable assets become the victims in a horror story. Intellectual property is one of the most terrifying tools you have. If you're a creator or other entrepreneur ready to build a frighteningly powerful brand and business, you need to know how to use it, but you don't have to face the darkness alone. To learn more about protecting your creations, your name, your business, and your legacy, you can book a consultation with me at kingpatentlaw.com. I help entrepreneurs across the U.S. make smart, legally sound decisions about their intellectual property and business issues. I'm an attorney in Champaign-Urbana, Illinois, and I serve intellectual property clients nationwide and business clients in Illinois. If this episode helped you survive the horror of learning about how to protect and manage your intellectual property and business, please like and subscribe if you haven't already. You can find all of my other frighteningly good content on the King Patent Law website, at Spellbinding IP, Patent Trademark, and Business Strategy on all major podcast platforms, and at King Patent Law on most social media, because I'm everywhere. The information provided in this episode is for educational purposes only and does not constitute legal advice or form an attorney-client relationship. You should not act on any information presented here, or really anywhere online, without first seeking the counsel of a licensed attorney, perhaps me, for your specific legal needs.